You're listening to the Valley Current.
Jack, I'll turn it over to you.
Great. I also did a few slides to sort of set the tone. First, I should check to make sure people can hear me, because I sometimes talk for 5 minutes and people start waving saying, we haven't heard anything, but we do see your slides. Can you see the slides and can you hear me?
Yes.
Great.
Well,
so there's only about a dozen slides. Just to set a little context here, I now run a nonprofit called the Foundation for Creativity in Dispute Resolution. I also am the managing partner of a law firm, although more of my time these days is moving towards mediation. It's not quite full-time. I imagine at some point it will become more full-time work. In general, let's just see a little bit about me. Again, this is sort of someone threw this in from marketing. I'll skip over it, but I can give these slides to folks. I made my way from New York to Silicon Valley. I did it, far earlier than our anniversary. I was in Silicon Valley back in the 1970s with the view that we were moving in a different direction. I was quite shocked being in Silicon Valley to see what had happened to New York. Of course, we're celebrating that 20th anniversary tomorrow, and I'm sure there'll be a lot about it. What the foundation did, it was formed about 20 years ago, which is why I tied the two dates together. I won a big contingent fee IP case and had a lot of money, really a lot of money. A lot of people said retire. And I said, no, I'm going to give most of the money to a foundation I'm going to start, which is going to study what I call the future for mediation and the future for dispute resolution. And some of that research generated a concept that's called CDR, which is creative dispute resolution, this idea of using zealous creativity over zealous advocacy. As we know, most of the lawyers that come to mediation treat it like it's a trial. Will often try to be as persuasive as possible as opposed to as creative as possible. One of the pieces of research that came out of the funding that occurred was that, in fact, if you could set the tone where the idea is the participants are going to co-create a solution, you have a much better chance of an outcome that will be much better. Now, that's hard to instill in lawyers that have had traditional legal education, and some of what the foundation does is give grants to law schools and business schools with a view that maybe the future will be more a peacemaker lawyer as opposed to a zealous advocate. So what's this idea of creativity over controversy? And we tried to brand it. I don't know if we can turn it into a brand, but the mediator acts as an instigator. The instigation is how to think of the problem as though it's something that has a solution, and all the people for some moment in time and space, ideally together, nowadays by Zoom, are going to actually co-create a solution that they're going to feel is a better outcome than what could occur at a trial or arbitration or whatever the alternative other dispute resolution mechanism is. So, of course, Computer Law Group does litigation. We try cases. I tried a case last week in San Jose. I have to say it was a novel experience. Everything was behind plexiglass. We were there, but we weren't there. The judge was there, but to some degree you couldn't get a good read on him because he was wearing a mask. I don't think you can get a good read on the witnesses who wore masks. Some witnesses made a point of not wearing masks to amplify that they felt like they were more credible than the ones who were behind masks. Obviously, in mediation by Zoom, just like today, there's no mask, so you can see the body language, you can understand what people are saying. It was an interesting experience, to say the least, because to some degree I questioned whether, had we done the trial by Zoom, we might actually be better off. And I can give lots of reasons why Zoom might have trumped that particular trial. But we did the trial. It'll be interesting to see sort of how the actual record, given that the court reporter did not want to be there. So the court reporter bagged out. The court reporter decided to convince the judge that and there were a couple, one was a man and one was a woman, that they would do this by Zoom. So the trial was live, but the court reporter wasn't there in the courtroom. So the court reporter had to stop occasionally saying, I didn't get that down, just like what happened a minute ago. There was a freeze or a lock on the screen or whatever. So we're going to see how the record turns out. Of course, I think appellate courts are going to have something to say about this. So I moved from New York in the 1970s, came to Northern California. This is sort of roughly what it looks like. Some people say, well, what is Silicon Valley? It's probably more of a brand than it is a geography, but the geography is pretty expensive and pretty important. Hopefully all of you have come there. A few facts just by way of history, and then I'll wrap up to the main point, is the father of Silicon Valley is an unknown person, a professor named Frederick Terman. He was a Stanford professor of engineering back in the 1920s. He basically encouraged students to start companies as opposed to go into academia. A lot of the reason Silicon Valley exists is because Fred Terman had a vision that the future would be different. I'm going to try to take the background off, and maybe that'll make the connection better because I'm getting some indication the connection is unstable. But his view was, let's try to invent and innovate for the real world. And an example of his students were William Bill Hewlett and David Packard. Do people remember this company? Of course, it's HP, Hewlett Packard. Now it just goes by two initials, HP. It really did instigate a lot of the startups that occurred in Silicon Valley. He became the dean of engineering, the provost, and essentially Silicon Valley 1.0 was born in the age of mainframe computers. From there, we see things like Apple Computer and personal computers. That's really Silicon Valley 2.0. That's when I came into the picture in the 1970s. Silicon Valley 3.0 happened with Google roughly in the 1980s, but it became the 1990s quickly. Silicon Valley 4.0 happened with the dot-com bubble, with a lot of social media and e-commerce, which is still pretty much what's happening. But now we have an emerging Silicon Valley 5.0 that really is about connection and different apps sharing different data and different information over time, quickly, in real time, and with artificial intelligence, what I like to call augmented intelligence, helping people make decisions, helping people take actions. So there are sites like this that many of you may not know, but they exist. This one's called Do Not Pay. It's an app you can download on an iPhone or an Android phone. Essentially gives you advice about whether you should pay a traffic ticket, because it helps you figure out what your defenses are to a traffic ticket. Now, I don't think there are really lawyers that practice in this area anymore because it's been commoditized, but there used to be lawyers who would theoretically be willing to fight traffic violations and the like. I think that's gone away. That's been commoditized by all the self-help books and apps like this, and there are more of them. If you search the App Store, you search the Android store, and you just put the word legal in, you'd be amazed at how many apps will just come back instantly and tell you what's going on. So now turning to mediation, what does this mean for mediation? I borrowed this cartoon from a slide from about 5 or 6 years ago that was given by one of the CLS members. I forget who, but I have the slide deck, and I saw this slide and I said this is actually something interesting, because this is the one thing that doesn't happen on Zoom. Everyone faces the camera and they literally don't immediately caucus, although we should talk about whether that's what people are doing, because there are people, mediators, who believe starting in separate caucuses is the better way of going than starting together. And I think in many ways, a lot of times the mediator has to get a sense for the temperature in the room. And I'm not sure how easy that is to do by Zoom. I'm not sure, frankly, how easy that is to do with plexiglass dividing people up. Obviously, this is the old style mediation, but oftentimes the temperature in the room can be very hot. So we engage in mediations. The ones I do are typically big business cases, typically a lot of intellectual property issues, typically treated like a chess match, where someone is looking to win the game as opposed to compromise it. And you have to change the momentum to one where people can imagine making a deal. You have to imagine that by the end of it, people really want to sign some type of settlement agreement, sometimes some type of new license agreement, sometimes even a merger or a major transaction type agreement that no one realized coming into the room that they would be able to actually get the result of. And you as a mediator might actually have saved them finder's fees or broker's fees of 5% of what might be a $100 million deal. Now, unfortunately, you don't get paid that way. You don't get paid for the real value that you bring to the table. But I've had deals where litigations have become major transactions, and the fees that were paid in mediation were a tiny, tiny fraction of what the actual fees would have been had Goldman Sachs or JP Morgan or one of the other major financial arms actually negotiated and been the underwriter in the deal. So I want to use an example. Many of you may be paying attention to this. Certainly, as I was finishing this case in San Jose, the lawyers for the Elizabeth Home Theranos case were starting to enter San Jose, and there's a major case going on. And this is Elizabeth Holmes outside the federal courthouse in San Jose just a few days ago. The trial started. Technically, the pre-trial started a couple of weeks ago, but the actual trial started on Monday. I'm told that yesterday, after day 1 or 2 of the case, or maybe day 3 of the case, a juror called in saying that he or she had had some contact with someone with COVID, and the judge shut down the case for at least a day. So I don't know whether it's going to restart with an alternate today. I think they've got about 18 jurors, so they've got enough. They've got more than enough jurors and more than enough alternates, given in a civil case in federal court. For those of you who don't practice in the U.S., civil cases can be as few as 6 jurors, and by stipulation even less. I'm sure it's because it's a criminal case, it's 12 jurors, and they've got 6 alternates, maybe even more than that. This was the lineup to the courthouse for the spectators that wanted to get in, which is rare to see this sort of thing, but basically it was a lineup of people all wearing masks because that's mandated by the court. And of course the lawyers were still trucking boxes in, which was sort of funny because you would think in the day of the internet everything would be in the cloud, but of course they were bringing in exhibits with paper and the like. And I asked myself, could that case, at least the civil side of that case, because there's some major civil litigation involving the investors, including against various third parties, could that case have been resolved somehow by mediation? Now, it's a criminal case, and it's obviously not typical or even very likely that a criminal case will ever go to mediation, although I think there are some people that experiment with whether plea bargains should be subject to some sort of mediated outcome. I don't know if you know, Ken, whether that's something that can ever occur or whether the judges want to weigh in. But I think what we're seeing happen in Silicon Valley is sort of a new emerging state of affairs for mediators, which is you have to be conversant with technology. You have to be willing to see what technology can do to help the process. It's certainly becoming more global, hopefully becoming more intelligent. I would like to imagine it's becoming more trusting and more passionate and all these other things that I suggest can be summarized using this idea of quotients like health quotient, intelligence quotient, and the like. But you have to wonder to some degree whether, given the fact that people are meeting in person less, we're more likely to have more disputes and less resolutions with respect to negotiated outcomes, because people are not really negotiating much anymore. Or is the opposite true? Because there's more convenience, people actually will negotiate more and or will mediate more ahead of filing suit, because filing suit means you're going to get a trial, at least in California, maybe 2 to 3 years from now. It's even in federal court, there's a huge backlog from the number of cases that got stalled during the last 18 months. So to some degree, those are some of the questions, that's some of the backdrop. This is something that I hope will stimulate a bit of discussion. I'll take this down. I'll certainly make the slides available. You can attach them to the video and the audio on the channel, and we can also, to some degree, and this is a tool that we used in the preparation that Ken and Claudia and I used with Wayne and Sasan, we put together when we were having our discussion an actual voice-to-text translation of the discussion. And the thing I found most memorable was something that Wayne and I were debating with Ken, which is, can you actually see the white of the eyes of the individual participants by Zoom, or is that going to be lost in translation, so you cannot make the kind of credibility assessments? And we had a very lively discussion about that, and if I had the video and audio, I would clip it in at this point, and people would laugh, because Ken, I think, took the opposite view, that he thought there was a way that you could actually assess credibility almost as well as being in person, although I think we ultimately convinced him that in-person credibility assessments were mandatory, and that's why we still have jury trials. So with that, I'll stop and take the screen share down, and certainly hope that this generates some further discussion.
But so creativity and lawyers, I don't think they go well along.
I would beg to differ. I think that lawyers are fundamentally very creative people. They get hammered in law school, and they get hammered. They get hammered in the initial practice, particularly if they go to work at a big firm, and they get hammered, and we lose a lot of creative lawyers in the process of that hammering. But I do think that if you can get a group of lawyers together with a group of clients that really are willing to, what I call, suspend the disbelief that it's possible to create new value, 1 and 1 = 3, some bigger pie emerges. And the business schools are teaching this. The business, particularly business people, the better sort of enlightened business people that are out there, are recognizing that what they bring to the table is creativity, and the business schools are more open to teaching creativity than the law schools have traditionally been. That's going to change. But I still am firmly of the belief that what you're saying is correct, in the sense that the model of law school and law training is very sort of in the box, test this, test statute of limitations, test standing, test causation, test damages, test duty, and it's very checklist oriented. But the reality is, the more complicated the cases are getting, the more creativity is actually required. And my own view is the profession, the mediation profession as a whole, will become a creativity profession more than a legal risk analysis profession in the long run.
Let me interrupt you a minute, Jack.
Yeah.
I'm going to kick it over to Shane, because I agree with Jack. And what Shane, Maroney, and the folks at New Era ADR are doing, they're being creative. They're going out and marketing using technology. So Wayne, coming back, you may want to chat with Shane what they're doing. And they're being very creative, because they're basically some lawyers, practitioners that saw they were being hammered, I guess, Shane, if you would. And so they left to set up the New Era ADR with e-mediation, e-arbitration, and various iterations of it. And they're being very creative. Shane, go ahead. I'm talking about marketing here.
Yeah, thanks, Ken, and thanks, everybody. This is really interesting. I'm really glad I was able to join. Appreciate you having me. So as Ken said, I work for and co-founded a startup, so that's why I'm not wearing a tie or a suit. I actually got away from the legal profession so I could avoid having to do that anymore. But I'm a former attorney myself, and I was general counsel for a company in Chicago, where I met my other co-founders, and we were all attorneys and general counsels facing very similar problems. And related to really, and this is, I think, particularly an issue with the American system, the unpredictability of cost and time related to disputes. And so we started, and I won't get into the whole background here, I know I'm not a speaker here, but and I'll get to Ken's point, but we started a technology company in order to be able to address that problem of unpredictability. And doing so, we threw it online, made it virtual, so that's kind of where this fits into this conversation. streamline the procedures. In the process, we've almost become this marketplace, really, where parties to a dispute, and this is true of a lot of ADR organizations, but because we're 100% virtual and have a national reach, we've partnered with the NADN, which Ken showed that presentation at the beginning. In terms of marketing, we feel like we've actually, and I thought it was really interesting, Wayne, when you were talking about narrowing your market, because our approach has been actually by going virtual and being available anywhere in the country, you've actually broadened your scope. Generally, the ADR industry has been very word of mouth, like you mentioned, and local. And while I agree, one of our main ideas and proponents is that we want to match the correct neutral based on their experience and based on their practice area with the right case. So narrowing your focus in that respect, I'm 100% on board. In doing so and going online, though, you can also, partnering with an organization like us, you can take that narrow focus and expand it beyond whatever local jurisdiction that you might have otherwise been relegated to in the past, pre-pandemic. So really interesting talk. Thank you for having me. Appreciate the intro, Ken.
Any other comments, thoughts, disagreements?
Yeah, I can give a different perspective. First of all, I've seen your statistics scan regarding present and future online mediation. And personally, I can share with you that I definitely still enjoy much more the in-person mediation. I've been mediating both in-person and online and hybrid in the last year. And for me, the real thing is still the in-person one, even though I do a lot of Zoom mediations, and I really see the advantage of having the hybrid meetings, because it helps a lot sometimes. But the contact, the eye contact, the body language, it's never the same in the Zoom. Even though percentage-wise, success percentage-wise, it's working in the Zoom as well. But for me, talking about bringing our own passion, I bring my own passion better to the room. I enjoy it much better. And for me, it's not only about success percentage. It's also about my having spark in the eyes when I go to work. So I just want to say that my future vision is not only online, and I'm really thankful for the opportunity to have all three platforms available: in-person, Zoom, and hybrid. Of course, and I agree with Jack, there was one of the slides was about technology and bringing us the ability to work internationally much better, much easily. That's what we are doing right now. So for international mediations, for sure, Zoom has done miracles. Jokes aside, marketing is another, it's a science, but it's another word that we use for promotion, for advertisement, they have all different purposes. But what's the difference between mediation and what do you do when you do mediation advocacy? Do you market mediation? Do you market yourself? What do you think?
Well, I can tell you what the research is, and it's not something that people want to hear, but it turns out that if you buy from Google certain keywords, you will get more leads. So as bad as that sounds, because as lawyers typically, I don't think my firm has spent a dime on advertising in any general sense. I certainly know newspaper advertising, nothing like that. But if you look at the Google research is very much that certain keywords are worth, and remember the way Google works, the party has to click your ad and presumably get through to your website or wherever your ad leads before Google gets paid. So just putting the ad up. So for example, if we do sort of a live test, I don't want to try to sell Google because I don't personally buy into this, but generally speaking, the first place that most people go is to Google. And they'll put a search in. So say they're in Silicon Valley and say they have an IP dispute and say they're trying to find a mediator. They will search IP mediator in Silicon Valley, and whoever buys that string or those keywords is going to have their ad come to the top. And typically, for one reason or another, people will instantly gravitate to that top ad and click through, even though it has a little demarcation that says ad. Historically, I always thought if it said ad, people would shy away from it, but the research actually is people do that. That's how you get the top of funnel of a lead if you're doing marketing. Now, I can tell you that probably if we did a survey, I bet we would find out within our group or even the larger group from the slide deck that Ken showed, I bet 90%, 95% of mediators do not buy Google AdWords. Now, big mediation firms like JAMS and FedArb and a host of others, they do. They have budget and they do buy those AdWords, and we could probably prove that in a second by doing a simple Google search with a share screen. But by and large, you have to imagine a future where people are instantly going to Google and instantly wanting to see what Google spits out in response to a set of keywords. The advocacy part or the educational part would be presumably through your website or podcast or whatever else you're doing to make your brand or make your personality shine so that people can get a taste of it.
Tune in next time on The Valley Current.